The first witness is expected to take the stand in the Senzo Meyiwa murder trial this morning. It is expected to start afresh under a new presiding judge, Ratha Mokgoatlheng. Now, the new judge says all applications will have to be brought again. That includes the bail applications of the 5 accused. Meyiwa's then girlfriend, Kelly Kumalo, may also have to apply again to have a watching brief in court. Well, let's bring in to the conversation to help me understand how this works exactly, senior legal practitioner. It's Zola Majavu making time for me this morning. Mr. Majavu, good to have you with us. And please help a layman like me understand, is this essentially a clean slate? Everything said before in court, it's expunged or it's erased, it's irrelevant. We start from zero. Is that correct?
Good morning, Gareth, and good morning to your viewers out there, and happy Mandela Day to everyone watching. Firstly, yes, it is a clean slate. It is not unheard of. It is not uncommon. It would typically have happened, God forbid, in the event where any presiding judge seized with the matter were to pass away. So for all intents and purposes, it will proceed as if it never happened. So it means the state is at liberty to put the charges afresh, which may or may not be identical. Some further charges may be added or others may be deleted. The defense has a right to plead again. They may plead differently to how they pleaded previously. And the order of the witnesses may not necessarily be the same, but it is open to the state to commence with the witness that they feel is ready to set the scene. So strictly speaking, both parties have an added advantage in that they've had a dry run, if you like, because they have a sense of what to expect. But it is, for all intents and purposes, a clean slate, and either party is at liberty to bring whatever applications they may be instructed to do. For example, a fresh bail application is not unforeseeable. A further application for a watching brief or any other preliminary applications that may have to be taken can still be adjudicated afresh, so that as and when the trial itself gets going, you don't have these unnecessary side shows that have potentially cost this trial significant amount of judicial time.
And I'm going to ask in a moment, Mr. Majavu, about the time that it's taking to get this case underway. I'm curious, though, if the state and the prosecutors are able to change, because it is now a clean slate, I'm wondering, are the accused in this case, are they allowed to change their statements, their affidavits? Because, as you say, it was a bit of a dry run for everybody. But I can't imagine a scenario where an accused can go ahead and change statements after the fact, after they know how the prosecution is going to proceed.
They can, notionally. Remember, at this stage of the proceedings, none of the accused persons have had anything to say. Because remember, the onus is not on them to prove their innocence, but rather on the state to prove their guilt beyond reasonable doubt. The closest that they would have had to say would have been in their affidavits in support of their respective bail applications for those who attempted to have their bail applications going. But in terms of their defense, there is no obligation on them to provide the prosecution with whatever statement they intend to make in the fullness of time, if and when they do take the stand. So it is basically an open sesame for them. They can do whatever they want in the exercise of their defense. So the state is not in possession of any statement that would have been made by the defense at this stage. But yes, the short answer is they can change whatever stance they wish to adopt. And in fact, even those that may not have applied for bail previously, they are at liberty to do so. They can do so on the basis of what we typically call new facts. A set of new facts would have been the duration of time through which they have been held in custody without bail. It's a substantial fact that any court, other than the court hearing this actual trial, may well be inclined to entertain, and maybe entertain favorably if each accused person then discharges the reverse onus that rests on them. But I wouldn't be surprised if they wish to avail themselves to the possibility of a fresh bail application.
How is this in the interests of justice, Mr. Majavu? I'm curious because, as you say, and I mean, I know there's probably a much wider ranging conversation we can have here around delays of court cases and the reason this court case has essentially been reset because of what happened with the previous presiding judge as well. Justice-wise, how is this serving the best interest of it if everyone now seemingly knows everyone else's gameplay?
Well, unfortunately, that is just how the cookie crumbles. Remember, the interest of justice is a round circle. You also have to counterbalance the rights which are constitutionally entrenched, the rights of the accused persons. It doesn't matter how interested or interesting the matter may be to the public. The fact of the matter is it is a court trial that must be underpinned by the rule of law and taking into account the fact that we live in a constitutional democracy. Their rights are entrenched in Section 35, and no amount of delay can trump those rights. And most importantly, you would remember that most of the delays were not occasioned by any of the accused persons per se. Some may have been on account of their legal representatives. They were perfectly entitled to run the case the way they did. Not that one agrees with some of the stratagem that was employed. But at the end of the day, that is simply how our rule of law goes. In fact, let me remind you and the listeners or the viewers out there that we had between 1990 and 2000 or so, we had a trial pertaining to what got to be dubbed the Buremach trial. That trial ran for about 12 years. 12 full years at a cost of no less than 36 million. It took as long as it had to because of the number of accused persons involved, the nature of the evidence led, and the trial judge was seized with this matter for over a decade. And in the end, the matter was finalized and the accused persons were sentenced. So there is no timeline to how the wheels of justice should grind. Ideally, the rules of justice and the wheels of justice must grind as soon as possible, but there are other competing rights. Unfortunately, the accused are entitled to a fair trial, and also on the other hand, the family of the deceased is also entitled to closure and to know that justice was indeed served, regardless of the outcome of these court proceedings. So I'm not fazed by this. It is unfortunate, but the sooner the trial starts, the better. And I think, in my view, the new judge is correct in insisting that all of these pre-trial hearings or procedures and issues must be resolved now. Can you imagine if the trial starts and the issue of legal representation from a finance point of view rears its head again? It means the trial has to stop, and it may well affect those whose legal rights issues have been resolved, because it's always a problem when you have multiplicity of accused persons and multiplicity of legal representatives. The issue of their respective diaries also comes into play. So I think the sooner all of these pre-hearing issues are resolved upfront, the better the chances are that the matter will go on relatively quicker. Lessons have been learned, I think, all around by both the defense and the state, and we do appreciate that a new judge has already set the tone of how he wishes the matter to proceed. But no one can ride roughshod over the rights of the accused persons, because those are constitutional entrenched. And similarly, the state also has a right. They dominate the proceedings. They have a right to run the case in whichever way that they are determined to do so. But at the end of the day, the balancing act has to be done by the presiding judge.
Oh, the new presiding judge in this case as well. I always appreciate your time. As always, Advocate Zola Majavu of Majavu Inc., a senior legal practitioner, joining us this morning.